So what's estate planning? Well, up on the screen there's a technical definition for it. It's actually a professional service. A professional service whereby we identify what the client's goals and objectives are. We need to understand the client personally, their relationships, their personal circumstances, their goals in life, their financial situation, and importantly their structures, the structures that they have their wealth embodied in. And then it entails then understanding how they want that wealth to pass to the next generation and doing it in the most tax effective way. So it involves actually quite a lot of areas of law, and I lecture this subject at university, and about a year ago I was sitting one day in class, giving the lecture, and there was a guy sitting in the front row, and you could see the expression on his face. He was trying to take it all in, and then the penny dropped and you could see his face light up, and he put his hand up and said, "Does that mean getting your shit in order?" And yes, so I said, yeah, perhaps I say to clients getting your affairs into order, but he got the point. So what does the marketplace expect? Well, I differentiate between what I call an informed consumer and an uninformed consumer. Sadly, most consumers are uninformed, and many nowadays apparently die without a will. In fact, the website for the New South Wales Trustee and Guardian suggests that 45% of people will die without a will. New South Wales Will Registry website suggests that 60% of people will die without a will. Now, dying without a will, dying intestate, is probably the worst legacy that a family can be given by a deceased loved one. Because loved ones will go through grieving, trauma at the death of a loved one. But when the loved one doesn't have their affairs in order, then that grief can only be exacerbated by the lack of action by the deceased. In a little while I'll talk about the problems that people incur with a poorly drafted will. And just by way of comment, people that do have a will, vast majority of people would have what I call a simple will. They don't have a sophisticated will. Now, informed consumers are a bit different. Once they know a little bit about it, they actually understand the process and the value of estate planning. And once they have that level of knowledge, then they're more likely to want a sophisticated will. Now, the perception is out there that a will is a simple document. And the law profession, legal profession itself has a lot to answer for as far as that's concerned, because there's things like Free Wills Week, and you get a free will with your conveyance, and it devalues in the eyes of the consumer, the value of the advice. So yes, a will can be a simple document. However, it's the advice around it, the estate planning advice, that can often be of a much higher level. The media itself also gives a lot of misinformation to clients, and the next two slides just illustrate that. It's on the Sydney Morning Herald website I went in, and on the same day I found two separate articles. The one up on the screen at the moment, talking about the triumph of the homemade will, yet another article saying don't risk a do-it-yourself will. So conflicting messages. It reminds me of a story I heard once. Went to a seminar where a leading QC who specialises in estate disputes was giving a presentation. And he started off by saying, "I love homemade wills. I think they're the best thing since sliced bread. They keep me in business." And what the story illustrates was, yes, lots of people who do their own will stuff it up. People hate filling out forms, and the court system is littered with people with cases where people have tried to make their own wills and have not been successful. I could, if we had more time, I could tell you stories about Peter Brock, Brett Whiteley, a lot of well-known people who tried to save a few dollars by doing it themselves, but ended up costing their families a hell of a lot more in legal expense. Now, informed consumers, I know there's a lot of accountants and financial advisors here today, and it's actually your profession, the legal services profession, which is a big encourager of people to be able to get estate planning advice. Lawyers tend to be reactive. We tend to deal with things when our clients ask us to do things. Whereas financial services people tend to be more proactive. You're the type of people who will say to a client, you need this done. This is something I would recommend. And estate planning is an illustration of what the financial services industry is certainly recommending to its clients at the moment. So what motivates clients to have their estate planning done? First of all, tax minimisation. Most clients want to minimise the taxation impact of their death. In other words, clients say to me, I don't want the tax commission to be one of my major beneficiaries. So putting in place structures that can minimise the tax payable on death and also the tax that beneficiaries may be paying in the future. Maximising asset protection. And what I mean by that is people generally want their beneficiaries to be the ones who actually get the benefit of the inheritance. They don't like the idea of inheritances being lost to creditors of beneficiaries or in property settlements after failed relationships. So building in structures which can help protect an inheritance are a prime motivator for clients. And finally, getting it right. In other words, minimising the chances of disputes arising amongst the family later on. Nowadays, informed consumers will actually ask for a testamentary trust or a sophisticated will. I can recall a couple of years ago, I had an elderly couple come to see me, and they were presented as a very simple couple. So I sort of had a little bit of chit-chat to them beforehand, and they said, oh, we've heard about, and they use the expression testimonial trusts, and we think we should know more about it. And they told me the story about how they'd spoken to their own solicitor about it, and he said, oh no, you don't need those, they're too complicated. You don't want to rule from the grave, don't want to use trust to rule from the grave. And they'd spoken to a second solicitor who said much the same thing. And they contacted me because they'd read an article in the Herald about the benefits of testamentary trusts, and I'd been quoted in this particular article. So I sort of said to the clients, well, can you just give me an idea of in the event of both your deaths, what would be the value of your estate? And he sort of looked at his wife and said, about 20. And my first thoughts were, 20,000? And I said, 20? And he said, oh, 20 million. And it was a lay-down misère. They needed something much more sophisticated than they had in place. They had a lot of property, they had 4 children. It was going to be of a great value to their children. And once it was explained to them, they couldn't do it quick enough. Lawyers who undertake estate planning need 3 main factors. First of all, they need the appropriate legal and financial knowledge to be able to advise the client. Secondly, they need the personal skills to be able to relate to the client, for the client to be comfortable in talking about what are often very personal things, skeletons in the family cupboard, plus their own views about family members, so being able to deal with those sort of issues. And finally, we need the appropriate tools to be able to obtain information from the clients and then properly document their wishes. Now, I've taught estate planning at university level for a number of years, and I also run seminars for lawyers, accountants and financial advisors, and quite often through the Financial Planning Association, they run a specialist course for advisors who want a designation in estate planning. So I teach at some of those courses, and I'm often asked, well, what could you recommend as a good precedent for a sophisticated will with a testamentary trust? Well, I'm pleased to say that today I've got one that I can actually recommend, and that's the new Cleardocs Clear Will product. And what I'll be doing today is illustrating how it can be used using a case study of Amy and Luke. But prior to doing that, I just wanted to show this slide, which has got 4 pictures on it. It's a way that I can explain how a testamentary trust is used. Because quite often when you start talking to people about trust, their eyes glaze over. So if you look at the slide, there's a safe. So you think of the trust as like a safe, and there's a key to the safe. So whoever's got the key controls it. They can open the safe, access what's in the safe. So the trustee has the key to the safe. Any trust has a rule book, a trust deed. And in the case of a testamentary trust, that is the will. So the will maker sets down the rules for the trust. And the final picture up there is a toolbox. And I talk to clients about, they can give their beneficiaries the trust structure. They can decide who has the key, who controls the trust. And the toolbox is a box of tools and powers that the beneficiary or the trustee can use. And those are powers, their discretions, their options, and generally they're used to make it more tax effective for beneficiaries and build in asset protection. So I find sometimes if you explain it in terms such as that, lay people can understand the concept a little easier.